And without further ado, I'm going to just introduce Holly Stiles from Disability Rights of North Carolina, as well as Lashana. Is it Lashana? Lashana, that's beautiful. Lashana Baldwin from the Division of Aging and Adult Services. Welcome.
Hi, thank you. So my name is Holly, as they mentioned, and I'm an attorney with Disability Rights North Carolina. I see some friends in the audience, but I'm curious to know how many of you have heard of Disability Rights North Carolina? Okay, good. So there's some people who still haven't, which is excellent. We always like to meet new people. So my presentation is talking about really the legal background on who has the authority to make decisions and when. The way I like to do presentations is I would prefer that if you have a question that comes up or if something I'm saying is not clear, for you to stop me right then and ask a question. Because I know this information, so I don't learn anything by going through the whole presentation. So it's really here for you. So please feel free to interrupt me. And we may, in the interest of time, start deferring some questions for afterwards, or after my presentation, I'll be happy to stay and answer any other questions you might have. I've got a stack of my business cards as well, so that if you do have questions that come up, one of the things that we do is we provide technical assistance to individuals who are assisting people with disabilities. And also, if you have clients, and we'll talk about who those clients might be, they may be appropriate for our services. So we also want to make sure you have our number so you can refer individuals to helping transition to disability rights if appropriate. So, I titled my presentation, Who's the Boss? Because that seems to be the theme, is who can tell me what to do when it comes to the transition process. So we've talked a little bit about Disability Rights North Carolina. Just for those of you who aren't familiar with us, it's a protection and advocacy system for people with disabilities. We are federally funded and federally mandated to investigate complaints of serious abuse and neglect, advocate for the legal rights of people with disabilities, and to tell people with disabilities about their rights and support their self-advocacy efforts. And all of our services are free to people with disabilities. So we don't charge for any of our services. However, if we're successful in a litigation effort or some sort of other legal effort, we may ask the court to award us fees for our work. So we're a not-for-profit, but we're not a not-for-loss, or we're not a for-loss, or whatever that expression is. So we try to do what we can to make sure that we can continue to provide more and more services. So decision-making authority is a legal construct. Up until the age of 18, parents are assumed to be the decision maker for their children, but at the age of 18, the decision-making authority vests in the person themselves. And so for you to have decision-making authority for someone else, it's a legal construct. There has to be some piece of paper that gives that authority. So in guardianship, a court order issued by a clerk of court defines the scope of authority of the guardian. And when you have a power of attorney, a representative payee, a living will, or any other sort of document, then that's a written contract between the individual giving the power and the person they have given the power to. So if you ever have a question about who has decision-making authority, it should be in writing. There should not be a question, does this person or doesn't this person have decision-making authority? So when you're in a situation where that becomes unclear, show me the paperwork. And if that person cannot produce paperwork that gives them permission to make decisions for someone else, then I personally would default to the person with the disability as the decision maker, because again, until I see that piece of paper, I have no authority to take away their ability to make decisions, and I have no legal relationship or legal right to talk to someone else about them. So you look at the paper. I thought it might be interesting to know, since the presentation's about the conflicts that arise, how many people here have already been doing transition work? Okay. So, and then the newbies. People who haven't done it before, who are just learning about it now. Got a couple? All right, 'cause not everyone's hands went up when I said everyone's done transition work, but then I didn't get the same hands going back. Okay. So I'm just curious if anybody would be interested in sharing a time when somebody said, I have the right to make decisions, and this sort of a conflict arose. I'm curious if there's some real life experience. We've got one over here. All right. They're coming to you with the microphone.
Whoa, that's really loud. Hi. I did case management work for a lot of years, and a lot of times when we would do enrollments where we needed signatures, parents would just assume that they were their adult child's guardian because they had a disability, and so we really had to be clear about going to court. But I did have one situation where the mom wasn't the guardian, the individual with the disability was in charge of her own life, but that mom tried everything she could to get service providers to give limited information, really push her this way, that way. So that was nothing.
We have another example.
Or you take the back room?
Where's this?
She's right here.
Hey, I get this a lot in the hospital. I'm a case manager, social worker there, where I get patients and family members are always trying to say, you know, we have the right to make decisions, but there's never any paperwork that's produced. You know, so a lot of times we have to go with, you know, next of kin or spouses if there's no paperwork in place. So we get asked that a lot by family members, or how can I get guardianship or power of attorney in the hospital?
So I'm a disability rights attorney, and so when I hear, you know, how can I get guardianship, it makes me nervous because, you know, I hate people who get guardians who don't need them. So, but anyway, I'll leave my personal opinion to myself. We have another example.
Hello. I have a lot of families that think because they have power of attorney, they can still make all the decisions. And I have to often say, just because your power of attorney doesn't relinquish their right, the individual's right to make decisions. They make their own decisions until they're incapable of doing so.
And that's an excellent point, because power of attorneys are not substituted decision making. So that's the difference between guardianship and power of attorney. Guardianship is a substituted decision making paradigm. So if you have a guardian, the guardian literally steps into your shoes, and the person under guardianship, if it's a full guardianship, not literally, but almost literally ceases to exist in the eyes of the law. They do not have a separate identity once they have a guardian. Whereas with powers of attorney, essentially it's a shared decision making, that the power of attorney has the ability to make decisions, but the person who gave the power has not lost that ability either. So that's an important distinction, and thank you for pointing that out. We have another example, sure. Sure.
So my question is related to guardianship within the context of education and students getting IEPs. For students that are awarded the state, and they may have had a surrogate parent attend IEP team meetings, if the student continues in school up to age 21, are they allowed to still have a surrogate parent, or who attends those IEP team meetings? Because obviously the state or DSS, it would be a conflict of interest for them to do that. So what does guardianship look like in those cases?
So when a child turns 18, their guardianship vests in themselves. They become an adult. So in a situation where somebody had a guardian as a child because of a unique situation where the natural parent wasn't available, then when that individual turns 18, just like any other child, guardianship vests in them. So if there hasn't been a power of attorney or guardianship or some sort of agreement from the student who's now 18 to permit someone else to make educational decisions, then nobody else should be making educational decisions after the age of 18 except for the student. All right, so I'm going to keep going, but again, I want you to stop and ask me any questions as you have them. So I want to talk about what guardianship is and isn't, and then what powers of attorney and other alternatives to guardianships are and aren't, because I think it's important when you're talking to families, they have the best interest of their loved ones in mind. most of the time. I'm not, I'm sure there are other situations, but most of the time they have the best interest of their loved ones in mind. So we want to be able to give them information about what the alternatives to guardianship are so that they can continue to support their family member or their friend or whoever it is that is transitioning back home, but so that they understand the different, the ramifications of their actions. So when somebody has a guardian, what does that mean? When somebody has a power of attorney, what does that mean? So we want to make sure we're giving people good information. So we have to have good information ourselves first. So guardianship, again, this is a legal proceeding. And once someone, and it could be any interested person, makes a motion for someone to have a guardian, then the clerk of court in the county has an obligation to hold a hearing and determine if the person is incompetent. And if they're incompetent, then they appoint a guardian. So it probably seems like a one-step process, but technically in the eyes of the law, it's a two-step process that if you have a guardian, you have to have been found incompetent first. So if there's been an incompetency finding, then, and the burden of proof is a clear and convincing evidence. So it's supposed to be a pretty high standard that someone is not able to make decisions for themselves. Then the clerk can appoint a guardian. It can be a general guardian, a guardian of the estate, or a guardian of the person. And it can also be a person, corporation, or disinterested public agency. So Life Plan Trust, I don't know if they do guardianship, but the ARC has a corporate guardianship program. The disinterested public agency in North Carolina is DSS. So I was just curious, I was going to share some stories with you about, the guardianship process. So I represented an individual who was seeking treatment at Broughton Hospital, and the hospital had determined that she needed a guardian. Based on my review of the evidence, I did not think that that would be the right outcome because she seemed capable of making her own decision, and it seemed to be motivated by a desire for her to take her psychiatric medicine. And one thing that a lot of families think, and a lot of, in the hospital context and all kinds of different situations, that if you get a guardian appointed, somebody will take the medicine. Right? I mean, you're laughing, but that's a pretty commonly held assumption that if I get a guardian taken, get a guardian appointed, then that person will start taking their medicine and they'll be healthier and we won't have any psychiatric issues down the road. That's a common misunderstanding. So I found myself in that situation where that was essentially the desire of the hospital. They thought if she had a guardian appointed, then surely she'll take her medicine. But one of the things that people don't realize about guardianship is you can't force medication. The only time you can is on an inpatient psychiatric unit where somebody's been involuntarily committed. So that's just kind of a misconception that guardianship will provide that resource, but it doesn't. So the hospital had convinced the family that they could not be the guardian. And the family had said, we're willing to be our mom's guardian. We want to help her. I'm willing to be co-guardian with my brother. And the hospital just not steamrolled, but definitely made the family believe that they couldn't be the guardian. And so I just want people to understand that sometimes there's misperceptions about what guardianship is and what guardianship isn't. So in that case, I was really glad I was a part of that case because we had what I've been told was the longest hearing in Burke County Courthouse history, and the first limited guardianship in DSS history in Burke County. So these things are not going to come easy. I tell you this, you already know this. You're already dealing with people who have different opinions and guardianship issues are coming up, but these issues are they're so emotional, and it's so hard to make inroads sometimes. But when you persevere and when you get somebody like disability rights involved, I'm just suggesting that perhaps there can be a better outcome. So I do want you all to know that we are a resource for those types of things. Okay, so the three types of guardianship we talked about were the general guardian, guardian of the state, guardian of the person. There's also something called limited guardianship, and I was talking about that in the Burke County case I just described. Does anybody know, are you familiar with limited guardianship versus some other type of guardianship? Familiar with limited guardianship? Okay, I'm seeing a few hands, but not many. Okay. So when somebody has a guardian appointed, they have to be found incompetent, but incompetency doesn't mean that you have to be unable to make any decisions at all. It just can be construed to mean that you can't make certain decisions. So for example, in this one, the slide says that some people may have the ability to make certain types of decisions but lack the capacity to make other decisions, or can manage some affairs but not others. So for example, somebody may not be able to manage their money very well, but they're an excellent cook. They can shower, they can eat, they can get dressed, they can, live a full life. They're just really not good at managing their money. A limited guardianship would be perhaps just to have somebody who is a guardian of the estate, who just managed the person's affairs as financial affairs. Or perhaps in a limited guardian of the person, you could have somebody who is a guardian of the person but only had authority to decide where the person lived, for example, to make sure they had adequate services and support. So the guardianship capacity questionnaire, which is on our website, we have a self-advocacy resources section of our website, and there's a guardianship section which talks about guardianship and restoration to competency. There's a guardianship capacity questionnaire which the clerks sometimes use, but we also think it's a great tool because it goes through all the different areas of decision making and talks about, can the person cook? Can they shower? It really breaks it down, and you can then say, okay, well, if they're able to do all these things, let's not have a guardian for those things. Let's have a guardian for just those things they're not able to do or need help with. So that's a great resource. We use it all the time when we're trying to decide whether or not somebody's competency should be restored, for example, or if there's a different alternative guardianship arrangement for a person. One of the reasons that guardianship is different than a power of attorney is that you lose rights under guardianship. I told you that you cease to be a person in the eyes of the law under guardianship. So one of the rights that you lose is the right to sit on a jury, and then any other rights that are spelled out in the guardianship order. So if you have someone who says they're the guardian and they show you their paperwork, you need to read that paperwork because they may or may not have the authority to make all the decisions for that person. Their authority may be spelled out in that paperwork in a way that you don't want to. So somebody tells you I'm the guardian and you say, okay, I'll deal with you and trying to help this person transition. You don't want to inadvertently take away some of those person's rights if the guardian doesn't actually have full decision-making authority. So you want to make sure you're also respecting that person's rights and making sure you're not assuming that they don't have the ability to make those decisions. The rights that somebody might retain under guardianship, and this is why you need to look at the paperwork to find out what those rights are. They retain the right to marry. They retain the right to vote. There are some guardianship orders that specifically have taken away the right to vote, but it's actually a constitutional right under the North Carolina Constitution to vote. So that's something that we're particularly interested in, that we want people who may be under guardianship to continue exercising their right to vote. But that's the fundamental right, that you get to decide who your representatives are, who's going to be your elected leaders. So we don't want to take that away from people unnecessarily. We want to make sure that they're exercising all the decisions that they have available to them. You may retain the ability to make a will. It depends on the capacity of the individual on the day, and if there's like a will challenge, they would look at whether or not those witnesses thought the person couldn't make a will. I mean, it becomes more complicated, but just because you have a guardian doesn't mean you can't have a will. You probably retain the ability to be a witness, but again, that just kind of depends on the situation, and it would be up to the attorney or whomever to see if that person was a reliable witness. You can enter into some contracts, and you probably retain the right to drive. In North Carolina, if you are found incompetent and have a guardian appointed, the DMV gets a notification from the clerk of court, and they're supposed to have some sort of a hearing before they cancel your license. That process is not always smooth, so if somebody gets a guardian, there's a good chance their license will be canceled. And they can appeal that, and we encourage them to appeal that, but it's something that they need to understand, that it may happen automatically without a pause. Any questions about the rights lost and retained so far? Have I bored you all? Okay, yeah. Hold on, we've got two questions. Whichever one gets there first.
Okay, do you have any resources for people who would like to pursue guardianship? Because it can be kind of a costly process. Do you
Do
have
you have
any
any
ideas?
resources that people want to pursue guardianship what?
Well, just let me use example. I have an elderly couple that are caring for their 42-year-old son who was had an anoxic head injury, and they need to pursue guardianship for him, but they don't have the financial resources. So where would I have them go?
Well, disability rights has taken the position that we're not going to assist people in getting guardianship because we want people to retain the maximum decision-making power possible. So I would talk to DOS, but Tisha might have a, Lashana, I'm sorry. Making a fool of myself right in front of everybody.
She's got one.
You may be able to scroll, I'll take the bottom of my level there.
There you go. Hi. Yes, you do have options. Anyone interested in becoming a guardian for someone can always reach out to the Department of Social Services in the county where the adult resides for assistance with that process. You can go to the North Carolina Guardianship website and you can find the forms and everything that you need. And again, reach out to DSS in the county where the person lives for assistance with petitioning the clerk of court for guardianship. There is no cost to reach out to Department of Social Services because again, we understand it is a costly process, but it is free. You can reach out to DSS for assistance at no charge. You will find that there may be a small filing fee once you enter into the guardianship process, but for general questions or assistance with the process, DSS is an option for you.
So to further that, they're actually allowed to talk and walk you through all the 9 or so different forms that it takes?
The DSS is there, and they are available to help you to navigate through that process. They're not going to give you legal decisions, but they are there to point you to what you need to do to help you navigate the process, but they are not going to give you legal advice.
Are we talking adult services?
We are. And every Department of Social Services has an Adult Protective Services unit. And so you can go to the DSS, ask for someone in Adult Protective Services to assist you.
You had another question?
When someone is about to turn 18, what's the timeline for parents that want to pursue guardianship? Does that have to be done? Do you start the process beforehand? Does it have to be done on their birthday?
And again, I'm coming from the Adult Protective Services realm of this. We would hope the County Department of Social Services, if they are involved with someone in child welfare, that there is a plan in place prior to the child turning 18 to assist with guardianship. I am not sure what the time limit is from the time the child turns 18, but we advise counties to have a plan in place prior to their 18th birthday.
Hi. To answer the question, my understanding is that if a parent believes that their child needs a guardian, they can begin the process before the 18th birthday. I'm not sure exactly how far before. The age 17 and a half is sticking out of my mind, but I don't know if I'm just making that up.
6 months in advance.
I'm sorry, what?
6 months in advance.
Okay, 6 months in advance. And I just want to clarify something. Disability Rights has taken a position that we want to promote alternatives to guardianship. And I just want to be very clear that guardianship has its place, and there are times when guardianship is appropriate. And in other presentations I do, I discuss that in more detail. But the reason that we've taken the position that we're trying to promote alternatives is that guardianship is super easy. Everybody knows about it. Not as many people know about alternatives. And so it's our duty to promote the dignity, independence of people with disabilities. So that's why we've taken that particular position. But I just want to make sure that people appreciate that there's a place for guardianship. We understand that, but we have to promote the alternatives because nobody else does. So that's our position on that. Yes. You've got a microphone.
So I work with young adults that have a primary mental health diagnosis. If they're 17 and a half, what can they do if they don't see guardianship as something that they'd like to have?
What are the alternatives, you mean?
Yeah, so what would,
Yeah, we'll
What's
get
their-
into the alternatives.
okay.
Yeah, that's the second half of my presentation is just trying to get the background on guardianship so people understand when somebody shows you a guardianship order, what that means. But then now getting into the alternatives. You have another question?
Yes, I have a question. I'm currently working with someone to help him transition out of a skilled nurse facility, and his niece is his guardian, and he has no clue how that happened. And I'm assuming, because he's fairly new on my caseload, so I've met him before he even did an application, but I'm assuming he may want to reverse it if that's even possible. But she limits everything. Like, we went through heck trying to even see him. And we had to, I don't want to say threaten, but it was like, well, you're kind of violating his rights, so we might have to bring in the ombudsman. So she kind of let us, see him with that part, but he has no clue. Honestly, I don't know how guardianship was obtained from him as well, so what is a resource for him maybe look into, I'm assuming?
So there are two options. If the individual still needs a guardian, then you can get a successor guardian appointed or another guardian. But the next slide is becoming one's own guardian again. So that's his other option.
And can I just interject here for a second? We're just thinking about time and flow, and
Yes.
I think probably what we'd suggest is that at this point to allow you to go ahead and finish out the entire presentation, and then let people kind of batch their questions, because
Not a
it
problem.
might be that you'll be telling some information that will help answer questions ahead of time.
Absolutely, not a problem. Thank you. So if you are somebody who has a guardian, then competency is a changing status, and there are also lots of people who have had guardians appointed who maybe could have made their own decisions, but because they have a disability, it's very easy to get a guardian appointed. So if the individual would like to have their competency restored, or somebody else involved in their life believes they can have their competency restored, then a restoration of competency is an option. And so, some people may recover, some people may gain new skills, or some people maybe just never needed a guardian in the first place. So the person who's under guardianship, their guardian or any other interested person can actually bring the motion to restore their competency. It has to be in the same county where their guardianship was entered in the first place. And something to think about is where they live currently may not be the county where their guardianship was created. So that can get to be tricky to figure out where that guardianship originated from. I would imagine, but I can't say this for sure, that the clerks of court have a way to look up the person's case and find out the county where the guardianship was created. I would imagine, but can't guarantee. So we've talked about guardianship. What about the alternative? What if there's somebody who needs some help but maybe doesn't need a guardian? Or maybe, they need a guardian, but you can also do the equivalent assistance with them with the alternative decision-making arrangements. And this, I think, would be helpful when you're talking about conflicts that arise between decision makers. I think this is a way to maybe address some of those conflicts, to say, you're concerned about their ability to handle their finances. What if we had a representative payee established for their Social Security benefits? Would that make you feel like their finances were going to be kept in better order, for example? So this is the summary. We're going to go through them. All the ones that talk about finances have the piggy bank on them. So Social Security allows you to have a representative payee appointed to receive your benefits. And this is not the guardian. So this is something that a lot of parents and guardians are not aware of, that if you are a guardian or a parent, you are not entitled to receive Social Security benefits on behalf of someone else until you have become a representative payee, which requires paperwork filed with Social Security. So, and if you're not the representative payee and receiving some of these benefits, it is potentially subjecting you to some sort of legal action by Social Security. So I don't know how often that happens, but you definitely don't want to risk that unnecessarily. And the representative payee acts very similarly to a guardian of the estate in that they receive the check and make sure the person's necessary expenses are paid, and then any leftover money they're supposed to, safeguard and to use appropriately. So perhaps it's for a vacation, perhaps it's saving for something else, but they're supposed to make sound financial decisions. So, and just to point out, most of the nursing homes, adult care homes, et cetera, are currently the representative payees for individuals. So if you have somebody transitioning, you're likely going to need to address this and talk about getting a new representative payee appointed. Special bank accounts. So if somebody's not good with money, perhaps you can have a bank account that requires 2 signatures to take out more than $500 or whatever it might be. And this is something that's going to vary bank by bank. So you're going to have to speak with the bank to figure out what those options are. A special needs trust. If somebody has a lot of money, and typically this is going to, and the situations you all are dealing with, since somebody's already in a facility-based setting, they've probably already received any sort of trust. They may have already received the money that would have gone into a trust because of the fact of the timeline of all that. But this trust is a way to shelter money for a person with a disability from Social Security and Medicaid and any other public benefits, because it's the recognition that the person is not very likely to become self-supporting in the future because of a disability. So thinking about somebody with a severe traumatic brain injury who has a feeding tube and isn't likely to return to work, for example. A special needs trust, if that injury was the result of an accident and they got some sort of lump sum settlement, you can put it in this trust, and then that way they can still receive Medicaid, they can maybe be eligible for waiver benefits, et cetera, and they're not being punished for this money that's a windfall, so if you didn't have this trust, that person would have to spend down all that money in order to become eligible for benefits again. But this trust recognizes that that person is going to need lifelong care, and so it would be unfair to make them spend down all their money to then become impoverished once again. So it's a way to shelter money legally. And home health care, I'm sure you guys are very familiar with this, which is if somebody's having trouble with bathing, cooking, dressing, etc., then home health care might fill in that gap. Not necessarily a guardian, because a guardian typically is not going to come over and cook and clean for you. If they did, sign me up. But so this is a way to fulfill the need. So I think a lot of people get hung up between having a person who can make decisions and somebody who's actually providing the services or the support the person needs. So this is a way to support them living independently. Healthcare power of attorney. So this is, again, it's a legal contract between a person and another person, giving that person the authority to make healthcare decisions if they become incapacitated. So if you have a power of attorney, healthcare power of attorney, it spells out if you would like people to take life-extending measures, put you on life support, et cetera. And it also terminates if the person has a guardian appointed. So that's something to keep in mind, because if you have somebody who has a guardian, having a healthcare power of attorney, it just doesn't make any sense. That document is just a piece of paper. However, in your power of attorney document, you can actually nominate somebody to become your guardian if you become incapacitated in the future. So it's that self-determination. It allows you to say your preferences. All right. An advanced instruction for mental health treatment. I wish more people were aware of this. I don't know how well it works, to be honest with you, but it's an option for, again, that situation where somebody has a mental health issue and maybe it's cycling, and they think a guardian will be a good answer because that'll help that person get treatment. The advanced instruction for mental health treatment allows somebody when they're healthy, when they're feeling good, to execute this advanced instruction that says, if I cycle again, if I have, a period where I'm not healthy, then I nominate this other person to make decisions for me. So that's exactly what a guardian would do in most people's understanding. So I think it's a really great alternative option where that person retains as much authority as possible without giving up any during those times of crisis. And a living will. So our healthcare power of attorney talks about making decisions, and it also says it's a declaration that I would like to die a natural death. There's also a separate document that just has the living will, which is a declaration that you would like to die a natural death. So the two documents, the healthcare power of attorney and living will, overlap somewhat, but the healthcare power of attorney has some extra authority attached to it, other than just the declaration of desire to die a natural death. And power of attorney, so we talked about a healthcare power of attorney, but power of attorneys are a general form, they're a statutory form, and they say basically you can give anyone any authority you would like in this power of attorney document. So the statute spells out like 16 or 17 different areas of authority, such as real estate, transactions, or bonds, or stuff like that. But it also says that the list is not exhaustive. So you can add whatever powers you might like. So a power of attorney, for example, could be used in the educational context. An 18-year-old could give their parent power of educational decision-making so that that parent could continue to come to the IEP meeting, but it doesn't require a guardian in order for the parent to participate in an IEP meeting. I've used power of attorneys in my own cases where I had a client who was becoming overwhelmed by the process, so she gave her brother a power of attorney to help her in navigating that case, because it was somebody she trusted, and when we hung up the phone, she could talk to him, and felt like she had some really good resources and support. So power of attorneys can be very wide-ranging. It's a statutory form. The healthcare power of attorney, the living will, the regular power of attorney, the advanced instruction for mental health treatment are forms that have been designed by the state of North Carolina. So I would recommend using those. They're free, they're state created, so you hope they're state approved. And so I think that would be a good option. The forms can be found on the Secretary of State's website, and they can be, I believe, I'm not sure if they can be found on our website. I would imagine that we've uploaded them. I'm seeing a yes, so I'm hoping that's true, that they are on our website. But again, I'm going to pass out my card, and if you ever want those forms, I'm happy to give them to Trish or to whomever, and they will distribute those forms. Again, they're state statutory forms. They're not my forms. They've been approved by the state.
We haven't announced this yet, but we are going to have a website and a learning community, online learning community, where we can post all the resources that people referenced today.
Fantastic. So the thing about powers of attorney, unlike the other documents that you have to be aware of, is that there are 3 types. There's some that are effective immediately. So I sign the document, and now you have power of attorney in whatever area I gave you. There are some that are springing. So if I sign the document and it's a springing power, it means that in the future, let's say I have some sort of horrible accident and I'm in the hospital and I'm not able to handle my affairs, the springing power of attorney would allow that other person during that period of incapacity to handle my affairs for that period of time. And then there's a durable power of attorney that says if I become incompetent or incapacitated later in life or after this is signed, that this person is now my power of attorney and it survives guardianship. So again, it's that ability to make decisions ahead of time and to figure out who I trust, who I like, who would I want to handle my affairs in advance, and you can name that person in the power of attorney and make it a durable power of attorney so they have those powers later. I don't know how it actually works in reality if you have a power of attorney and a guardian. It's supposed to survive, but then you have 2 people who can make decisions, so I don't really know. I'm sure there have been fights, and I'm sure they've been resolved in some way, but I just can't imagine that it's an easy thing to navigate. Okay, so what else do we have here? Okay, so those are all my slides. I want to go back and point out one thing. In my summary, and in the slides themselves, some of them had asterisks by them. Those ones are the ones that you have to have competency at the time that you execute the document. So they can't be binding unless the person is currently competent. So that was the healthcare power of attorney, the advanced instruction for mental health treatment, the living will, and the power of attorney would be something you'd have to have competency to execute. So a few other things I wanted to make sure I mentioned. So one thing is, just really like as a pro bono program where we try to assist people in restoring their competency. So if you have a client and they're interested in a restoration of competency, again, I'm going to pass out my card. That person is a potential client of ours. We're still growing our attorney network. I can't guarantee competency. There's an attorney for every person who would like to explore their competency. But the more demand there is, hopefully the more we'll try to grow the program as well. And it'll tell us where those areas of greater need are, where we might need to find some more attorneys to do this work. So that's one thing I want to make sure. On our website, we have a tab on the website called Self-Advocacy. Well, on our homepage, there's a Self-Advocacy Resources section. There's also a tab called Publications. And there's a Restoration of Competency packet in there that has all the forms that you would fill out to assist someone in restoring the competency. You can give them that packet as a transition coordinator, and they can work with someone else to make that happen. But that is a great resource, and we've had some great success stories. People have been successful in using our packet themselves and having their competency restored. And that's always a good day. And then finally, what occurs to me, and I don't know how the program works, but this issue of decision-making. What if there was a third document? We've talked about the guardianship form. We've talked about powers of attorney and alternatives. What if there was a third document that was a contract between the decision maker, whether real or imagined, and the person transitioning, and the transition coordinator that said that the decision maker who was participating was going to take all steps possible to encourage the person transitioning to voice their opinion, to make their wishes known, and to support their efforts to transition in a way that they want. And likewise, the person who's transitioning will sign that form saying, I will make my wishes known, actively participate, and then the transition coordinator would sign off saying, I too will support both sides of this. I just wonder if having that kind of like a formalized conversation at the very beginning might help people who have a tendency to want to make decisions, maybe step back and think more about it. Question, comment?
Holly, what you've essentially described there is a supported decision-making model, which you may know is gaining great popularity across the nation, and we are looking at here in North Carolina. There is an organization in, help me, I think it's Maryland.
Quality Trust?
Yes, thank you. Yeah. And they have lots of resources on their website about supported decision-making. The other resource I wanted to mention to Danielle about your question over here about help with restoration, in addition to the work that Disability Rights can do with individual clients, not to be mentioning one of your competitors, Holly, but the ARC of North Carolina also has a project around restoration to independence, and Bonnie Nelson is the person who heads up that project, and they are very knowledgeable there at the ARC of North Carolina about both guardianship and those alternatives.
They're all competitive, but everybody wins, so.
Holly, first of all, thank you so much for your comments. Thank you. There are a couple of things that Trish and I just whispered back and forth, just wanted to clarify here at the end of the session, and also just to continue to invite questions and comments. I wanted to draw attention to one of the early carousel activities. We talked about emerging principles, and one of the things that really resonated with a number of people was the idea that you don't have to be an expert. And I'm imagining, if you're like me, listening to all this, you may be thinking, my goodness, in 45 minutes, I cannot be an expert in this. And you are not supposed to leave being an expert, but knowing where to go for advice and how to navigate these options. So first of all, I just want to clarify, and Lashana, thank you so much for your technical assistance in this area as well. There was a lot of conversation early about guardianship in general, just first understanding what that is, and then also having access to exploring options that are alternatives. So I just want to make sure that I understand that DSS is probably your first good place to go to understand and to assist an individual and a family, that a transitions coordinator might run into.
Correct. DSS is an option. Again, if you are experiencing difficulty with that process, DSS is there to assist you with navigating the process. They're not going to tell you what to do as far as legal decisions, but they will help you navigate the assessment, what it is your loved one or the person you're caring for, what is it they're experiencing, and to kind of help you flesh out those details of their needs. It may be that the person does not require a guardian and they just need more support or what have you. So again, it's an option for you to reach out and talk with someone at DSS to explore your options.
Okay, great. And then to explore the alternatives, would you advise that people contact disability rights and potentially the ARC as well?
I
Is
would
that the next
suggest-
best?
Yeah, I would suggest starting with our website because our materials are, like, they're comprehensive and they're, I think, very helpful. And we've had people who have disabilities restore their own competency using our materials. So that tells me that they're easy to use. And after you've had a chance to familiarize yourself with those materials, then yes, absolutely, contact us with questions.
Okay, super. Another question, kind of real life, confronting the situation that many of you alluded to. So you're there, you're in the hospital room, or you're at a nursing facility or a group home, and you have the situation of conflicting conversations and dialogue with someone saying, I am the guardian, and no, and you know, especially today, that there might be some other alternatives. What is the first step a transitions planner or a transitions coordinator might do if they're stuck in the middle of a situation like that? What would you suggest as a first step?
So I'm interpreting your question two ways. So the first step, and I'm a lawyer, so I eat paper, what I do. I say, show me the paper. If you tell me you have this authority, I want proof. Because again, I don't want to take away somebody's decision-making and autonomy without proof that somebody has the right to make those decisions for them. And then from there, you know, I mean, that's one of the tragedies of guardianship and why we promote alternatives is that if the guardian and the person under guardianship have a disagreement, the guardian wins. And that's really just too bad, because if that person is saying, I do not want, and the guardian disagrees with them and they're doing something that is very clearly something the person doesn't want, unfortunately the legal right is with the guardian, and you have to follow what the guardian says.
One of the things that we've talked about within MFP is that dynamic and how do we navigate that. And you know, we often encourage transition coordinators and the teams to really try to get a sense of what's under the anxieties of the guardianship first. You know, like to think through, is this person may be asserting it, maybe she's truly thinking she has it, but usually they're asserting it because they're scared of something. And what's undergirding that fear, and what can we kind of have conversation around to see if we can solve problems that, you know, but it is important to know that just because somebody asserts that they have something does not mean they actually have it. And definitely a dialogue.
There's my personal fantasy, and perhaps I'm deluding myself, is in a hospital situation to have someone like me there that the hospital can call on in these types of situations to give on the ground advice and assistance about what the options are, and trying to walk families through that process, because a lot of times the hospital is the one saying, we need to get guardianship here because we need to discharge this person and we need somebody to find them a place to live and all that sort of stuff. So in my fantasy world, there's like a medical legal partnership between victims of domestic violence and hospitals that's gotten a lot of traction. And so I see a similar need for people with disabilities.
I have a thought.
Yeah.
You mentioned this last question you left your session with was to say, would this form be helpful? How close are you to being done with it?
How close am I to being
The
done with?
form, the prompting form that allows, a contract form. The idea that as a potential guardian with a potential person, that we develop this contract between each other. How closer is that to being accomplished?
So I was putting that out there as a hypothetical, as a good model. So I'm happy to assist in developing that type of form, but as far as I'm aware, That's living up here.
And I think it leads to what you're saying. It just begins to address the fears and the misconceptions that parents have going into that new dynamic. So I just think that you're very, very on track with that, and it needs to be done in a part of everyday practice when that conversation comes up. And I'd like to invite, and I guess I'll put it on the website, our program is a parent resource center in the Mission Children's Hospital in Asheville. And because this is such a big topic for so many families, that we have developed a packet with an attorney's support that actually maps all the steps out that a family would go through with the competency questionnaire, which is another really, really good tool that helps a family understand what might make someone incompetent and what not, because their perception might be different than what other people might perceive. And so that would be available on the web for people to mimic for their own county, because their own county's forms might be different.
Okay. Well, there's a hand in the back. I see you. And we'll start here and we'll go there. Okay.
Oh, thank you. I'm Debbie Lee from Charlotte, and am interested in your comments because you were just saying that sort of the guardian wins out sort of at all costs, and legally I understand that, but under the basic duties of a guardian, they have to seek the input of the ward, especially of their value system and their desires and wishes and those kinds of things. So that's the piece that I want you to comment on, is that I think there's often this clash between I'm the parent or I'm the person now in authority, and it really doesn't matter what you say or want now that I have the authority, which is, I think, one of the reasons that you guys take the position of preserving rights at all costs, and I'm totally with you. And the second is, how does that play out for disinterested guardians? Because while my experience is certainly not what you have described, that DSS is in place to assist that, I hear you saying it, but in our region, it doesn't happen that way, so that's okay. They are also typically the disinterested guardian and do not follow these basic premises either, because as an APS tenant, they have to do something that would not increase risk or those kinds of things.
Right.
So to me, those are at odds and put them in a conflict of interest as a default guardian. So just thoughts.
Do you want to defend?
And I do understand exactly what you're saying. However, legally, the guardian has, even if the guardian is the DSS, the decision is ultimately the guardian's decision. However, our guidance to all counties in the state of North Carolina is to, of course, include the interest of the adult. Our training,
Making contact with them in some way, right?
Exactly. Our consultation, our training is to always put the person first, to involve that person as much as possible. So that's from the state, that's our guidance, and that's our consultation. Now, what goes on at all the counties, it may vary, but our standpoint is to always consult with the adult and get their input, because we are making decisions about their lives.
To follow up on so part of what you've asked is a very soft legal question, in the sense that it's very mushy and there's a lot of gray area there. And they only gave me an hour, and you can clearly see, give an attorney a microphone, I can talk forever. So that conversation is absolutely true. You know, at this 30,000-foot level, the guardian has the right to, say what's going to happen. And then you kind of start digging down into how much is that guardian fulfilling what guardianship is envisioned to be. I think there's a big disconnect there in a lot of situations, but that's why, again, we promote restoration of competency and promoting supported decision-making, and really trying to encourage people to listen to people with disabilities about what they want. And I'll give you a short story that actually Betsy might know, because it's one of her employees, but did a presentation on alternatives to guardianship for the Disability Rights Conference in April, and had a short snippet of an interview from a young man named Tristan, who's now 18, and his parents were thinking about getting guardianship for him, even though they promote alternatives. That's like her job. That's what she promotes. And she just had this reaction when he turned 18. Just mom's instinct took over and just gut reacted and went and got guardianship papers. And realized as she was filling out the papers that she was doing the wrong thing. And so I interviewed Tristan about what it was like to be his own guardian, because he had come so close to not being his own guardian. And what was the most powerful part of our interview was that Tristan said that he did not tell his parents that he wanted to be his own guardian. He didn't feel like that was something he could tell them, because he obviously loves and respects his parents and didn't want to disappoint them and make them angry to tell them that he didn't want guardianship. But when she told him that they weren't going to be his guardian, he told everyone he knew for days and days that he was his own guardian. It was like the proudest moment of his life, and he was so excited about that. And that's what he always wanted, but he just didn't feel like he could tell them. So I think when you start listening to people with disabilities, all the paradigms start shifting. So again, give me a microphone. I'll keep talking. But Betsy, you had a question or comment? I'm sorry.
And this will need to be the last one.
Okay,
So-
I'll be brief.
Mhm.
At First and Families in North Carolina, we get many calls requesting to help pay for guardianship. And all of our staff know how to first make sure that people are aware of alternatives to guardianship, because that's kind of our bias first, that's our default. A barrier, I think, to helping support families moving forward is that, number one, when they call for guardianship, they're already at this crisis point where they're gotta get, and so they have the name and address of the clerk of court, and it's all the easy thing to do. And so when we talk about alternatives, we can't say, okay, go to this address, get started. That would be really wonderful instead of, or in addition to all the information. If information can be overload and a disincentive. But I don't know that there is such a directory that we could use on the phone when the person in Winston-Salem we're trying to encourage them, that we could say, well, here are 2 attorneys' names that know how to do all of those things, and help them that way.
Right. And in response to that, there are definitely attorneys across the state who are doing this work and are familiar with the alternatives. But obviously that is a private bar, and cost becomes a factor. So attorneys who can do a mix, yes, we definitely see a need for that. And I try to do what I can, but I'm also doing employment law, and I'm also doing, higher education cases. And so it just becomes a battle to fit it all in. But there's definitely a great need, definitely a great need.
Well, again, thank you so much, Holly and Lashana, both of you, and to all of you for your contributions. This whole room is filled with knowledge and expertise, so thank you so much.